我哋有足夠嘅法。
All right, members. We have attained the quorum and now call to order the Bills Committee on United Nations Anti-Terrorism Measures Amendment Bill 2017. Now it's time for us to elect Chairman of the Bills Committee, Mr. Yu Xi-wing. I nominate Mr. Gary Chan. Dr. Low Wai Kwok seconds. I accept the nomination. I have to take part in this election. May I call upon Mr. Paul J. to do us a favor? Mr. To.
好，而家咧就有提名咗一齊。
All right, there is a nomination of Mr. Gary Chan. Do I hear any further nominations? If not, I nominate Mr. James To. Mr. Wu, you nominate Mr. I don't accept the nomination. Sorry, beg your pardon. I'd like to say to have the floor to say more. Other than Mr. Gary Chen, any further nominations? I declare that Mr. Gary Chen elected as chairman of the Bills Committee. Okay.
好，多謝大家支持嚇。
Thanks very much for your support. Let's get on with our meeting. Let me put this to you, members. Do you see the need for vice chairmanship? I don't think so, because it is more straightforward. It is only an amendment bill. All right then. Shall we invite the administration in, and we will start the discussion on the bill. With us for this session are Deputy Secretary for Security, Ms. Mimi Lee, Principal Assistant Secretary for Security, Ms. Iris Lee, Assistant Secretary, Mr. Percy Leung. From the DOJ, Deputy Principal Government Counsel, Ms. Anthea Lee, Government Counsel, Ms. Elsa Chan. Just a reminder that this is to amend the UN Anti-Terrorism Measures Ordinance Ordinance Cap 575. In March, this was taken to the Security Panel, and members were generally in support, although some members expressed concerns over certain issues. Also, the administration has conducted consultation for 2 months. 10 submissions have been received that express support for the bill. Before I throw the floor open for questions, I'd like to call upon the Deputy Secretary to brief us on the bill first. All right, and without further ado, Ms. Mimi Lee. Mr. James To, just one point, Mr. Chairman. You said that there are public submissions. In fact, the information regarding suspected terrorists that raised a lot of controversy when the ordinance was enacted. Now, this is an amendment to the ordinance. I'm wondering whether we can arrange a public hearing. All right, Mr. To is suggesting a public hearing in January to March. There were public consultation sessions. 10 submissions have been forthcoming, all in support of the amendment bill. Do you see the need for a public hearing, Mr. Wu Chi-wai? Chairman, if I remember correctly, the February panel. Yes, the February panel. We discussed this, and now we have the bill in front of us. It will be different from a consultation on the broad principles, and I tend to agree with Mr. Toh that we should have a public hearing to consult the public. Dr. Loh Wai Kwok, if this is the reason, then I think it would be better for the public to be invited to give their written submission. The public hearing will not be long. If they can make available submissions in writing, I'm sure that there will be lots of professional bodies who would be interested. It would be quite sufficient. Mr. Raymond Chan, Chairman, I support public hearing. Normally, if there is such a suggestion at the Bills Committee, where practicable, I think we should adopt the idea. The Columbarium Bill, we had public hearings in the previous sessions, and Ivory, they are considering a public hearing as well. Do we have any urgency, any time limit for us to pass the bill that would make it difficult? Mr. Yu Si-wing, Chairman, this is not a complicated bill, and there has been a consultation conducted. I go along with Dr. Loh that if we need submissions, we can have submissions in writing. And I'm sure that the professionals can let us have their comments in writing. For the members of the public, I think the consultation that has taken place was sufficient. Any further views? If not, shall we have a listen to the Deputy Secretary? That there was a 2-month consultation. We'd like to hear from Madam Lee what the feedback was, and then we take a decision. Yes, indeed, Chairman, we've had 2 months of consultation. 10 submissions have been received, and indeed, we went to the Law Society and briefed them in detail the content of the bill, and we solicited their views, and we asked for submission in writing. Now, from the submissions, a number of them were from the electrical members, Mr. Ronick Chen, Mr. Yu Si-wing, and Mr. Yu Si-wing expressed concerns from his standpoint of the tourism sector. That this has to do with people traveling abroad. Both are in support, and they agree that the amendment bill will be enough to deter the terrorist activities. And this bill can deal with the wide variety of modus operandi adopted by the terrorists. Hong Kong is an international financial center. If you do not impose these controls, it would be easy for Hong Kong to become a place where they raise funding or to transfer the funding. Hong Kong would become a window for this to happen. And they have that in the bill, they like us to define terrorist activities in order not to infringe upon human rights and undermine normal training. We have received BPA, the Liberal Party, and DAB, all in support of the amendment. For the DAB, they hope that we would pay particular attention to the terrorist organizations resorting to the cyberspace for recruitment. The BPA supports the idea of regulating those who travel abroad for battles and so on. There is also concerns about the financial element, and there ought to be consultation in order to strike a proper balance. But basically, they feel that this anti-terrorist financing should be incorporated into the regime to make it more complete. The Liberal Party expressed the view that Hong Kong has the international duty to fulfill the UN anti-terrorist regulation, although they talked about protection of human rights. The HCAP expressed the view that they are in support of the 4 offences. They put a question to us regarding whether there will be any impact on the travel aspect in the finance sector. They hope that the administration would give them more guidelines so that the sector can be assisted to fulfill their added obligations. We have received the deposit taking company associations, and they didn't express any particular strong views. We've also received submission from a member of the public, and we have written to 45 different organizations, of which 10 gave us written submissions. For others, they did not express any particular view. So, Mr. Chairman, we feel that in the community we do get general support from the community, and we can get into the details here in this Bills Committee. Any further views? No. Please wait for me before you speak, Mr. Paul J. and then Mr. James Toh. Right, any urgency there, Mr. Chairman? I'd like you to get some clarification. Second, LegCo keeps emphasizing the importance of public hearing. I think we should observe this fine tradition unless there are other particular reasons. Also, it is also a fine tradition. If there is a suggestion, we should try to incorporate it as much as possible. And there is a criminal element. There is an imprisonment of 7 years, and we have to be careful with that. I tend to agree that there should be public consultation. I think since we've done the public consultation, we can have a hybrid approach. We can have an hour for public hearing and spend the rest of the time scrutinizing the bill. Mr. James Toh. Thanks very much, Mr. Paul J. This is similar to what I have in mind, unless members have strong reasons. There is a suggestion made by members. Now, I've been taking part in so many bills, committees, and subsidiary legislation subcommittees. Hardly do I ever make this kind of suggestion. You may get the general support. Can we get the balance for the fine details? If you ask me, I would very much like to hear from the public where we get a balance right. Like Mr. Paul J. said, this is a criminal offense with 7 years of imprisonment. For the first offense to prohibit any Hong Kong permanent resident from leaving Hong Kong to engage in this, that, or the others. Now, anybody leaving Hong Kong with the intent of doing something that this has not happened, this is something that's going to happen.
So what would constitute the act in question? We have to be careful. And terrorist training is not mentioned in the bill. We have the terrorist activity only. Since so many people would be affected by all these, so we should spend some time to listen to them. And if they all are all agreeable, we'll put our mind at ease. And if some human rights organizations point to some questions of balance, we would have to consider them carefully. Mr. Chan Ying, the Financial Action Task Force is going to conduct a health check on Hong Kong next year. So there's an urgency here to pass the bill. So perhaps we can have a part of the meeting time devoted to a hearing and then the rest on the bill. And shall we make use of the time during the summer break instead of waiting until we return in October? So if we want to have a hybrid meeting with hearing, let's do it in August or September to tie in with the timetable of the checks to be conducted by the FATF. Mr. Alvin Young. Well, the three members who have spoken have reflected what I want to say. The ED panel is going to have a public hearing on the establishment of a fairway near North Lantau. We're going to have a public hearing on even that kind of issue. Well, if we have a public hearing inviting views and only 2 show up, that we don't need an hour for that. But if there are many deputations coming and they give us very long submissions, and how can we say that they are given 30 seconds each? That there's no way you can rush this through. If I have worries, if I have doubts, I will ask questions. I will go over the contents one by one. Well, I'm familiar with this ordinance. If I am not assured, I would try to scrutinize in great detail. If the deputations are not as worried, I can, of course, do it more quickly, and I hope everyone can do this with ease of mind. Mr. Ma Fung Kwok. But there's no need to spend time on whether we should have a public hearing. If some members propose this, in order to listen to views from the general public, well, let's arrange it. I'll ask the Secretariat to make the arrangement to invite public views. All right. And now let's move on. Deputy Secretary, please brief us on the legislative intent and the contents of the bill. Thank you. Some members ask why we need this bill and also whether it's urgent and what the bill is about. So let me say something about this. Internationally, the efforts to fight terrorism are very critical. That we have different terrorist groups. Some countries are hit very hard. And terrorism has also spread to Asia, Southeast Asia, and also the mainland. From time to time, we had heard about incidents at the railway stations and infrastructure facilities. The UN Anti-Terrorism Measure Ordinance was enacted after the 9/11 incident. A group of fighters slammed aircraft into the World Trade Center, leading to a lot of casualties. The UN Security Council passed a 1373, Resolution 1373. And we have to pass this law to implement some of the recommendations. And also, terrorism activities are costly, and they will have to be supported by some financing means. So the so-called task force on anti-monetary financing come up with guidance asking member states to do something to their laws, and therefore we pass this ordinance to implement to fulfill our obligations under 1373, and also that there's the freezing order to be introduced on terrorist assets. So after so many years, has the terrorism seen the change? Yes. And there are alternative ways with people radicalized. They are now doing this in a city as lone wolves. For example, in Paris, the terrorists launched attacks in 6 locations at the same time, leading to huge losses of property and lives. Hong Kong is lucky. We haven't experienced any such attacks, but we need to do the right prevention. In 2014, the UN Security Council come up with this Resolution 2178 to handle certain matters. At that time, more and more people left their countries for another countries or to join some organizations to learn how to launch terrorist attacks. And also after they received training, they would be involved in the perpetration and planning of terrorism activities. So that UNSCR resolution asks all member states of the UN to come up with a legal framework to prohibit such acts. So the entire front line is moved to prevention. And the CPG, and China is a member of UNSCR. CPG wrote to us to ask us to legislate against such acts. And we need to do some preparation, of course. Now it's 2017. We are here in this council to do this. If you ask me whether there is any urgency, and I would say that it's better to be early than late, since terrorism is an important matter. And in 2018, as Mr. Chen has said, the task force is coming to Hong Kong to conduct a health check that is going to be a root and branch scrutiny of our Hong Kong's system in fighting terrorism or counter-terrorism financing. Our freezing process against terrorist assets has been said to be inadequate or too slow because so many procedural steps are involved. While we are doing that, the asset might already have been transferred out of Hong Kong. So this time, we are going to beef up our measures to fulfill the requirements of FATF. Hopefully by 2018, when they send people to inspect our system, they will be happy with what we have got. And then our reputation as a financial center will not be tarnished. As for the specific amendments, you can see those in paragraph 5 for the details of the proposal to be in gist. So we have 4 measures, 3 of them related to traveling. First one, we prohibit any Hong Kong permanent residents from leaving or going on board a conveyance with the intent to leave Hong Kong or place outside Hong Kong for the purpose of the perpetration, planning, or preparation of or participation in terrorist acts. So this is a ban on traveling to another country or from leaving Hong Kong. The second and third one are related to the first one. For the second offense, no one shall finance these people leaving Hong Kong for such a specified purpose. And thirdly, no one can plan or prepare or participate in such acts. And we have to separate the 3 offenses for efficient law enforcement by our LEAs. And the last one is about terrorist financing. We prohibit any person, it's a prohibition against any person who knowingly or being reckless as to whether a property is a terrorist property and handle such property, or to deal with properties are wholly or jointly owned or controlled by a terrorist or terrorist associate. If someone is specified as a terrorist and a terrorist associate, all the properties must not be allowed to be realized, whether it's a chateau or real property, all will be frozen immediately. We have conducted a very detailed analysis into this. If this is passed into law, we can fulfill the requirements of the FATF. Thank you, Chairman. We have 4 members who would like to speak. U.C. Wing, Ma Fong Kwok, James Toh, and Kenneth Leung. 5 minutes for the first round. Mr. Yu, Hong Kong is an international city. Annually speaking, we see hundreds of millions of people coming and leaving Hong Kong, coming to and leaving Hong Kong. And if we have a terrorist attack in Hong Kong, Hong Kong's reputation will seriously damaged. Our tourism and our economy will be severely damaged. This proposal seems to prohibit people from traveling to leaving Hong Kong for the purpose of terrorist activities. But this is a two-way street. We should also prohibit the traveling of terrorists. We should pass this into law as soon as possible to show our determination. Another 5C, to prohibit any person from organizing or facilitating the travel of individuals between states with the intention of knowing that the travel is for the purpose of the perpetration, etc., of the terrorist acts. We are a bit concerned about the intention part. You know, for a travel agent making the preparation of facilitating the travel, the identity of the traveler may not be well known. If the traveler joke that I'm going to be involved in terrorist act, you don't know whether it's a joke or not. If he turns out to be a real terrorist, then is the agent part of the organization of the travel? Because whether it's that terrorist make a joke or not was not known at the time. So the planner or the company organizing the travel may be punished. How do you define the intention or knowledge? How do you establish that the person intends or knows that the travel is for the specified purpose? The terrorism sector should not be worried. We have consulted them, and they have expressed their support for this. For the offense under 5C, the person must knowingly, deliberately, knows that that person is going to be involved in a jihad war or in the training. For example, he's associated with the IS, and you know that the background is so checkered, and you know that and you collaborate with him and organize the travel of that person. Only under this situation would you be in violation of the offense in 5C. Why do we set such a level of mens rea? Intention means that there is the knowledge. It's close to the very high, the highest level of knowledge.
And all prosecutions will have to be for the prosecution to prove beyond reasonable doubt before conviction. And in the evidence, it has to prove that this person did this on purpose and did this knowingly. And in fact, this is a protection for the travel industry, and the travel industry is in support. If someone with a mental problem, if he walks into a travel agent and wants a ticket, and if he's merely saying that he's a terrorist and a ticket is booked, then it would be hard for conviction to be secured on the basis of such a flimsy evidence. So, Mr. Yu, I can rest assured there. Mr. Ma Fung Kwok, Chairman. At the present moment, before we have this amendment, if the administration has some intelligence about somebody traveling abroad for terrorist training or wanting to raise finance in Hong Kong, now, with the legislation as it is, without the amendment, do we have any room or any measures for the law enforcement agencies to stop this from happening? One of the amendments is in response to the FATF recommendations. And to deal with the transfer of assets owned by the terrorists or terrorist associates. Now, if someone has the assets frozen, is there any avenue for the aggrieved party to lodge an appeal for the sake of fairness? Deputy Secretary, under the UN ATM ordinance, we do have certain constraints. And let me say this on the basis of the ordinance. The ordinance specifies what terrorist associate and terrorist assets are. We have the clear definition. Now, if the assets have to be frozen under Section 6, there is such a mechanism. But this is rather slow as a mechanism because they have to specify a property, and with regard to this specified property, an order will be issued to specify that the property cannot be moved, and the order has to be served to the holder. It can be a bank or it can be an account, let's say HSBC, for instance. And the bank will serve the notice to the actual account holder or the owner. And if you're a criminal element, you would refuse to accept it, and there is a process, and you have to satisfy all the processes to serve the notice to the owner. If he refuses to accept it, of course, under the law, we can show that all the steps have been undertaken. It's only in that scenario that the property will be frozen. Indeed, there is inadequacy, and therefore we'd like to move an amendment. If someone is designated as a terrorist, then the asset will be frozen. What about personal freedoms? We use other legislation in this regard. For a terrorist, if he has committed a criminal offense, he's likely to have been arrested. Under the crimes ordinance, we do have a variety of offenses like possession of explosives, offensive weapons, attempt to damage infrastructure, or any other criminal activities. All these can come under the terrorist acts, and he cannot be allowed. He will not be allowed to leave Hong Kong. Under the immigration ordinance, the immigration officers can refuse entry to anybody or can raise questions. I'm talking about Hong Kong residents. Yeah, about the mechanism. Yes, the appeal mechanism. If someone has the asset frozen, one can lodge an appeal. One can make an application with the court regarding the frozen assets, and the court will have a look at the assets to see whether it is justified. This is under Section 5 of the ordinance. Also, I'd like to say this to Mr. Ma Fung Kwok. If someone is regarded as a terrorist or terrorist associate and has the asset frozen, there is a compensation mechanism if his appeal is upheld. Mr. James Toh, I'd like to state my key principle that for ISIS, for instance, now ISIS is being bombed to limit its influence, and the terrorists are being arrested, or in extreme cases, one can use a missile to kill the terrorist leaders. The idea is to limit and exterminate the terrorist base. Now, I support this direction. This is the way to go. So I hope that they are withdrawing, and the network is recruiting people to train as martyrs and to engage in terrorist activities. I think globally we have to take some action collectively. I support this. As far as I am concerned, I think we have to ascertain whether that there is a clear definition for the key issues. I've seen, for example, the dishonest access to computer, or access to computer with dishonest intent. My view is that the government has been abusing this provision. They are testing the bottom line of the court. Now, once they get their way, they would do more of it. I am concerned that you would be taking advantage of this provision, or even abuse the provisions to test the court's bottom line. Somewhat of a technical nature. Say, for instance, Mr. Yu Si-wing cited an example a moment ago. Now, he is concerned about the travel agents getting into trouble. Now, let's not talk about a court scenario. If a travel agent owner is arrested and the asset is frozen, now how do you deal with that? Now, I'm not talking about the level of proving beyond reasonable doubt. So we have to be careful in this regard. Now, here we're talking about leaving Hong Kong. Now, if someone is carrying a gun on his way out of Hong Kong, then he'll be in trouble, of course. You must have some intelligence. I'm not sure whether the customs officers might have got hold of the ISIS scriptures in his bag. Now, there was a nun after 9/11 from the Middle East. She's traveling to the U.S. and she has a book about her spiritual spirituality. Now, she was questioned why she read this kind of book, and she, of course, she would read books of spirituality. She wouldn't be reading books about stock speculation. If I read about ISIS books or books on ISIS and to see how they operate, As a legislator, I would read about books about the triads, the origin of the triads, or the signs, gestures, and so on. Even lawyers, they have to read up on these kind of information. Now, all these poems are cited by the triads. Of course, I wouldn't recite them in public because otherwise I'd be in trouble. Now, ISIS, we're all aware of this. You say that they are going there for training, to have weapon training, explosive training. But if I just go there to learn about their scriptures, maybe 10 countries have come up with a definition, or Turkey, for instance, has called this terrorism. If I go to the U.S. To meet Turkey's rival, and Turkey has called this terrorism, and if I undergo some training, not so much about the use of explosives, then I might be in trouble. So I like to put this to the administration, how they can assuage my concerns in this regard. Mr. Kenneth, if you don't mind, let's hear from the administration first. Deputy Secretary, would you, is there a likelihood of the law being abused to crack down on the dissidents? And what about the definition of terrorists? Do you need to have a definition from the UN or a definition from Hong Kong? Who can give the definition? Can Hong Kong give a definition on terrorist organizations? I think it would be good for you to do some explanation here. Chairman, I've been only delighted to clarify and explain the situation for members and also the public. First of all, I must say that there is no intention of cracking down on anybody because of this bill. There is no abuse of this bill. We are merely implementing the UN Security Council resolution, and we have to make sure that Hong Kong remains safe as of now. We have to protect Hong Kong against terrorism. If you look at the wording, this is linked with the terrorist activities. Members can rest assured that in Section 2, there is a clear definition regarding terrorist acts. It says that it must involve the loss of lives and properties and also public safety and so on. And this is very clear. The intention has to force or threaten the members of the public to engage in these activities. Now, would certain activities be misinterpreted as terrorist acts? Now, let's say there are some electricians who turn off the grid in order to seek a pay rise. Now, for demonstrations and strikes and so on, they would be exempted. Now, for these outbound travel, we have to have the evidence to show that what they are doing comes under the Terrorist Act as defined in Section 2 of the ordinance. And Chairman, at the moment, you asked how we define this.
In the ordinance, we have definition for terrorist associations, and terrorist property. And it means that it's the person who carry out acts or assists in an attempt to do this. As for a terrorist associate, we're talking about a company or some entity to deal with the property. There are two ways to specify terrorists. UN would, from time to time, publish a list on terrorists and terrorist associates. The SAR government also accept such notices, and we would gazette the list. And the finance sector would update their list accordingly. Separately, there's another channel. The CE can apply to the court. And the court would have regard to the definition and the circumstances surrounding that particular individual, and then an order can be granted, and then the CE can gazette the order for the specification. As I've said, if someone thinks that he's been wrongly specified or named, or his property is affected, he can apply to the court for an order to relieve him. So we have a very closely linked definition related to Terrorist Act. I would like them to get this in writing. Why is it not Terrorist Act or training in Terrorist Act? You're talking about receiving terrorist training, not training in Terrorist Act. I just want to get a written answer. Please also look at the definitions in CAP 575. They are nothing new. The relevant panel has also discussed these issues. I will ask them to provide a reply in writing in the next meeting. Mr. Kenneth Leung, I have 3 short questions. I need to get some clarification in greater detail. In 2018, there will be the peer group review. Are you talking about Financial Action Task Force? Looking at our anti-money laundering measures, or the comprehensive anti-terrorism framework, including legislation and other measures? So what's the review about? That's the first question. I agree that the legislative direction in this bill is correct. The day before last, there was an interview in New York Times saying that some Indonesian maids have received ISIS training and they have now returned to Hong Kong. I cannot verify this. Can you handle these cases? I'm concerned that you are unable to handle such cases in Hong Kong. We know that some LegCo members cannot go to certain places such as Macau because we are set to affect internal security. If Macau issues a notice to the Security Bureau saying that I won't allow these people to enter Macau, and with this bill enacted, would you direct that these people should not be offered ferry service? Of course, I can save time. I won't have to spend money on the travel in the first place. Are you going to enforce the law like this? Well, it's not just about Macau. For example, Malaysia may also want to bar the troublemakers like us from entering Malaysia. They may think that these are the terrorists, although they are not as extreme. But what are you going to enforce? This law? Well, no one would say that we agree that you are terrorists. Well, but it's been alleged. I'm going to say something, and then I'm also going to ask Ms. Lee from the DOJ to answer the other questions on Indonesian domestic helpers. The legislative proposals are fully in line with the UN's requirements. We need to make this most suitable measures, implement the most suitable measures in the light of our circumstances. The design is about prevention of terrorist training or to prevent the traveling for this purpose. We're talking about traveling among states. We just want to prevent the problem from the start. The wording used by the UNSCR is rather complicated. It's in the electrical brief, in the footnote. And they talk about nationality, country, and resident country. They are very complicated concepts, and we have to bear in mind that we have the principle one country, two systems. We want to make sure that the effect is good and also is easy to enforce. So we're talking about Hong Kong permanent resident. And if it's an Indonesian domestic helper, should we just leave them out? There was an report on the internet about recruitment, some recruitment attempts in Victoria Park. The police did take it seriously and investigate. If someone carries out an activity akin to the radicalization of people, for example, to the possession of firearms and then trying to learn how to use them, it's an offense to possess firearm without a license. Within our criminal law system, we believe we can handle these acts. But around the world, laws on anti-terrorism are going to be stricter in the Western world because they have had terrorist incidents and they are very determined to handle them head-on. A police officer patrolling on the street can now confiscate your passport or my passport if need be. It's a very strict measure, but we don't need to do that. But if someone breaks the law in Hong Kong, we can arrest him or her, and if we have the evidence. And if this person leaves Hong Kong, we can inform the destination country through the Interpol so that it would be easier to collect evidence and pin down that particular person if he's a terrorist. We're going to monitor the situation as an ongoing process. So this time, we introduced this bill to comply with UNSCR 2178 and FATF's recommendations. Actually, this is the third amendment bill that we have introduced in light of the development internationally. Some members are concerned about that they are denied entry into Macau. All governments are in control of their immigration regime. We cannot control what Macau does. In Hong Kong, in the immigration checkpoints, the immigration department would try to prevent the entry of people which may affect our law and order. So to prevent terrorists from Hong Kong entering Hong Kong, we are going to step up our checks at our checkpoints. We do have a list of terrorists, and the list is gazetted almost every on the basis of fortnightly updating. So the immigration department can intercept these people at the checkpoint and ask questions about their purpose of coming to Hong Kong, if they have doubts. I'm talking about traveling of a Hong Kong permanent residents to another destination. Would you deny these people from buying a ticket to go to Hong Kong or going to Macau? Well, exit is not a problem for Hong Kong permanent residents. If after investigation, after we have followed this person, we know that this person is going to be engaged in terrorist-related activities. We'll prevent this person from leaving Hong Kong, and that person will also be committing an offense under the bill. Ms. Lee, Ms. Anthea Lee. Mr. Leung asked a question about the mutual evaluation to be conducted by FATAC next year and the scope of the evaluation. In 2012, the FATAC make a change to the list of recommendations. Instead of 14 plus 9, it's 42, and now we have recommendations on any anti-money laundering and how to counter terrorist financing. Next year, they are coming to Hong Kong to do mutual evaluation of members of FATAC. They will be covering anti-money laundering measures and anti-terrorist financing measures. In 2012, they changed their system. There are two aspects: whether the laws can comply with their technical requirements, that is technical compliance. But since 2012, they have been putting emphasis on the effectiveness. You may have laws complying with their requirements. They will also look at how effective they are. So let me return to the first question about urgency asked by some members. The evaluation will be carried out in the fourth quarter next year. There will be an on-site inspection and review piece. If we fail in this evaluation, what actual damage will be done? That depends on what kind of in what kind of areas we have failed. There are core areas and other tiers. They may have an enhanced follow-up, and at every general meeting they will ask us to report what we have done to address those problems. If the failure is partial, it's not as straight, but the scores will be added up. In 2008, we were unable to fully comply with the requirements, and then after 4 follow-up exercises, we then considered to be fully in compliance, and things return to normal. And so there are consequences. If we fail badly, then there may be a public statement saying that in this place there is a serious risk of money laundering or terrorist financing, and other members will be advised to be careful in dealing with Hong Kong.
Deputy Secretary, well, financial sector is a mainstay of the economy. If we do not do a good job as a gatekeeper, it is likely that Hong Kong might be manipulated as a terrorist financing center, and it might compromise our security. Touch wood, we don't have any terrorist activities in Hong Kong. There aren't many jurisdictions that have experienced that. So from the security point of view, let's not talk about the naming and shaming or the blacklisting and so on. Indeed, security-wise, there would be some implications. So we'd like to amend to further tighten the ATM regulation. Mr. Portier, anti-terrorism is supported by anybody. I don't think we should, in the name of anti-terrorism, limit our flexibility and affect the finance sector. The world over, there are many measures that voted down by Congress, even if they are proposed by the President. I don't think we should fall into this. Now, the FATF measures, I think we have to ascertain whether there is a need. In the U.S., they have very stringent measures, and if we follow these, it would be hard for Hong Kong. I'm sure you're aware of this, and you try to comply with the regulation. Now, for the now this has to do with Article 31 of the Basic Law, the freedom of travel. We have to ascertain how or whether these measures are going over the top to the detriment of people's freedoms. The Deputy Secretary said that we don't have to be worried because under the ordinance, the UN ATM ordinance, there are clear definitions. Here we're limiting the freedoms, and I'm looking at the definition again. I think I am taken aback by the definition. It is rather liberal. Industrial action, the DS said we don't have to worry because this is not terrorist act. The DEF regarding public health, electronic system being seriously disrupted, and the essential services being seriously disrupted. This exemption doesn't cover A, B, and C, serious violence against the person, serious damage to property, and endangering a person's life. Now, all these are very serious, so much so that we are concerned. But in Hong Kong, things like these did happen. Or there was a threat for this to happen. All these can become terrorist acts that do not enjoy an exemption. And they can be regarded as terrorists. And the personal freedom would be affected. Let's say traveling from Taiwan to the US, if this is enacted, then all these acts would be on the wrong side of the law, and the consequences can be really severe. Honestly, you said you consulted the travel industry. I'm not at all at ease about it. The travel industry is not fully aware of the details, not even the travel industry ordinance. The sector can represent everybody's interest because they are unconcerned about the issues. I've got so many questions, and this is by way of an introductory remark. I don't think we should take it lightly. We don't just follow suit regardless, because there can be severe consequences. Mr. Kenneth Leung talked about Macau, and indeed there are implications, and this kind of legislation can undermine Hong Kong's freedoms. I would urge for caution in this regard. Now, in terms of definition, we have to have a look at this. If you don't mind, the administration might wish to tell us more about the consequences of fulfilling the FATF recommendations. Did we have any contraventions in the past, and what were the penalties? Now, this is a sort of Damocles over our head. And I'm trying to ascertain how bad this sort of democracy is. Will this undermine our freedoms? Hong Kong is one of the freest places in the world, according to the Fraser Institute. For 6 years in a row, we enjoy top ranking. The U.S. Is 27th. I don't think we should do anything to undermine this at all. If I may, Chairman, extraterrestriality, this extraterritorial element, how will this be implemented? I look forward to some further explanation. There is another point I'd like to get in here. And now we have the details here. Now, for travel plans, some have already been planned, some are being planned. Now, you talked about the mens rea. If someone has booked all the flight tickets and made all the preparation, and then it was found that there is such a risk, what implications would this have on the arrangement? So will you tell us how this would affect the travel industry? That if things are being planned, if there are problems that occur, what effect would that be? Now, for the Hong Kong registered carriers, they will be caught. Now, how can you stop these people? If you don't stop them, what will be the consequences? Thank you. Deputy Secretary, well, a couple of questions there. We will make a written response regarding the FATF issue. There is a point about the definition of terrorist act. This is not something concocted by Hong Kong. In 2010, we had some discussion here. We took reference from the UK definition. We had this as the blueprint, and we also had reference to the Canadian definition. In fact, the definition is consistent among the Commonwealth jurisdictions. There are three major principles according to international consensus. First, threaten or act that would threaten the government and the members of the public. Second, the threat and the acts are intended to achieve religious objectives. Third, when these threats or actions are taken, it would involve serious violence, it would damage property, and it would cause serious damage to property and endanger people's life. In 2010, during the debate in the Council, some members expressed concerns about advocacy in labor activities. And this is a fabric in a democratic society, is part of the fabric, and this is an expression, freedom of expression. And so we have included some exclusions. Now, for those who are advocating labor activities and protest dissent in industrial action, in this amendment, we don't have any intention to amend the definition because this is consistent with the international definition. For anti-terrorism activities to be effective, we have to minimize the discrepancy because the terrorists can travel from one place to another and not become terrorists. And they can get away with it scot-free, so there has to be some sort of consistencies there. Chairman, with your indulgence, Mr. James Toh is not here. There was some misunderstanding. Now, we talk about training for terrorist activities. The legislation is very clear. We're talking about training for terrorist activities. In Section 2, there is a clear definition regarding terrorist acts. It's in connection with these kind of terrorist acts that one can look at the training as terrorist training. Now, there was a question about the extraterritorial application. That there is the extraterrestrial application. There are some ordinances that would have this element, because if someone has traveled elsewhere, like a Hong Kong permanent resident, it would then undermine the effectiveness of the ordinance. So in this amendment bill, all these offences would have extraterritorial effect. Like Mr. Paul J. said, Mr. Paul J. asked, how can we implement this? In Hong Kong, we have the MLA, the Mutual Legal Assistance Ordinance. We also have the Surrender of Fugitives Ordinance. We also observe the international covenants for serious terrorist offences. They would be included in the offences enshrined in the MLA and also Surrender of Fugitive Ordinance. These ordinances are derived from the UN resolution. If someone, a permanent Hong Kong resident, has moved elsewhere, prosecution can still be instigated, but it has to be done through the MLA and also the Surrender of Fugitives Ordinance. Has this ever happened? For these offences, now these are four new offences. We haven't done this. For anti-terrorist offences, since 2010, Hong Kong is and has been a very safe city. We're glad to see that we've never invoked this UN ATM ordinance. But for other offences like murder, arson, money laundering, we have a sophisticated system. Madam Lee from the DOJ is responsible for that. Members can rest assured, in particular in relation to anti-terrorism, all countries in the world would accord top priority to it. Now, with support for these four offences, then if a permanent Hong Kong resident leaving Hong Kong, I can't see how he can elude the dragnet from Hong Kong. Mr. Felix Chong, sorry, keep you waiting. In the paper, there is a mention of the terrorists, and the Deputy Secretary said that the administration would update the blacklist of terrorists, but in paragraph 4, it refers to terrorist associate. What is the definition of terrorist associate? How broad is it? For these terrorist associates, do you have a blacklist that you have? In other jurisdictions in Europe, for example, a terrorist has been shot dead, and the authorities would be tracking down the family members, and they found that the parents are not involved, but the siblings are also involved. Now, they are living under the same roof. The parents are not involved, but the siblings are. How do you make a distinction in terms of terrorist associates? How can you disregard the parents? Mr. Kenneth Leung also made a point a moment ago that let's say there are some Indonesian domestic helpers who have undergone terrorist training, and they've come back to Hong Kong, and we all know that they live in domestic helpers. They're living with their employers. If they use the employer's residential address for communication, would the employers also be criminalized for harboring the terrorist elements? And for these terrorist associates, how to actually make the definition. Thank you.
秘書長。
Deputy Secretary. Thank you, Chairman. That's a very good question. And of course, a matter of public concern. Terrorist associate is clearly defined in Section 2. We are talking about entities controlled by terrorists, including individuals and companies. Let's say a terrorist needs an organization to carry out terrorist acts as a disguise. For example, a branch company is set up, and they would get some individuals to run their errands. So they would be directly or indirectly in control of these companies, or they are directly or indirectly owned by these terrorists. In the case of a domestic helper, I know Mr. Jones' question is clear, but I don't want to target a particular sector. Well, if a domestic helper has done something like that, he or she may be barred from entering Hong Kong. Will refuse their entry. But what if they have already entered Hong Kong, or we did not know at the time, and then the helper lives with the employer? Would the employer becomes an associate? No, because the employer is not directly or indirectly own or control the asset. So it must be directly or indirectly controlled, owned by a terrorist. At the time when we discussed the previous bill, we were asked whether the lawyer would become an associate if he acts for the terrorists, and the answer was no. For body corporate, how would the members be affected? We'll have to look at the Criminal Procedures Ordinance. So it's possible that we can target an entity and members of that entity, if it's a body corporate, as terrorist associates. But in your case, in your example, the employer will not be regarded as such. Some terrorists are just individuals. They may not be associated with any terrorist organization. They may be turned into a terrorist by the information he or she receives. And what if they are friends in support of that particular individual? Are they terrorist associates? Whether a person, an individual, should be defined as a terrorist, we look at the acts and the surrounding evidence. Whether he or she is carrying out terrorist act, as we see in Section 2, whether they are engaged in acts which would cause serious violence against a person or damage to property, or intended to threaten a government or another organizations. We must have the evidence to convict this person as a terrorist. There is a mechanism to name these people, to specify this. Either the person is named by the UN or by the CE through an order from the court. So we'll look at the evidence, the character of this person's acts, and we need evidence. we would look at what is defined as a terrorist act in the ordinance, and then we would gazette the name to let everyone know. For example, Mr. X has been specified by the court or the UN as a terrorist. That would let everyone know, and it would be put on the surveillance list on our checkpoints, border checkpoints. So there's a series of measures in this anti-terrorism mechanism. As for radicalization of individuals in the US, the UK, and Europe, we have experienced acts carried out by individuals who, as a result of information on the internet, have become radicalized. Some carry out suicide missions. And Mr. Chung, please be assured that so far Hong Kong is a safe city. It doesn't mean that we don't have any individuals like those. The police is a very forefront of fighting terrorism. They would pay close attention to the development in terrorism. And if they have any intelligence, criminal intelligence, showing that someone has this kind of inclination, they will take follow-up action. They will monitor whether there's any a case of radicalization. So the principle we uphold is to go for prevention. It's better than trying to handle the problem when it's really a problem. Mr. Paul Chair, there's so many issues. I don't know where to start, and I know when it comes to fighting terrorism, we are all very concerned. We are all very concerned about epidemics such as SARS in the same way. But we have to balance this against our local conditions, our special characteristics, and the risks we are facing. And we should not blindly follow the standards advocated by other countries, including the US, because by doing this, we will lose our special characteristics. Under the common law system, we have principles on conspiracy, aiding and abetting, assistance, and so on. And you're now defining certain act. The definition of terrorist act is very wide-ranging. It said that it's already in CAF 575. In the past, we talk about money laundering as the focus, but now we are talking about traveling between states or leaving Hong Kong. And I have this question of time sequence. Something might not be known at the time of arranging the travel. And how do you handle the travel package if there's a problem? When the transaction took place, the problem might not be identified. If something is ongoing, what action should be taken by the organizer of the travel in order to absolve himself? When we consult the tourism industry, what are the organizations that you consulted? We consulted Hong Kong Tourism Board. Travel Industry Council of Hong Kong, Royal Caribbean Cruises Hong Kong is a cruise company, Carnival Corporate Hong Kong, because they are also involved in tourism. Altogether, we consulted 45 organizations from the finance sector, the legal sector. I'm mainly talking about the tourism. The tourism board is doing promotion of our tourism industry, and the TIC. I'm afraid that I have to point out that they have very superficial understanding of all these legal issues. I'm sorry for being a little bit offensive in making such observations. Well, we are doing this to protect the industry. If someone goes or leaves Hong Kong to participate in jihad wars or to receive terrorist training, we don't want the travel industry to be dragged into this. But you have to buy an air ticket and before you can travel. But we don't want them to be involved and be charged. What if they only knew about this in the course of the arrangement? Well, the threshold is very high. If there's no knowledge, there's no intention, you're not caught. That's why the travel industry did not offer comment. Actually, they welcome this. If I don't know, how can you charge me? There's no way you can charge someone without the intention or knowledge. Sorry. What if the knowledge came later? Let's say the air ticket allows the person, the Hong Kong permanent residents, to travel from different destinations, A, B, C, D, E. So if it's a Hong Kong company, is caught. If someone works for the company, they are also caught by this. What should they do? Should they recall that person or cancel the arrangement? If the terrorist or the alleged terrorist has already purchased an air ticket, it was not known at the time, the travel agent is not going to have a problem. But if we know that the terrorist is in a certain airport in the restricted area, or he has already boarded the plane, and if we don't know, he may have already traveled to another place, and then if we know that, then through the Interpol or through the international anti-terrorism mechanism, we will know that well, he may be in one of several countries, and we can disseminate the information to the local authorities. Well, you don't understand my question. I'm not saying there's a problem with there should not be a problem with the terrorists, but the travel agent which has arranged the travel, what should the travel agent do? Should the ticket be cancelled? And should he inform the whole world that I now know this is a terrorist, and no other travel agent should offer any further assistance? This is about the question of time and space. So what should be done? Just use your common sense. You can cover a vast span of time and space. If we know that that's the route of that the terrorist is going to be taken through the arrangement of a travel agent, and the police should take action, law enforcement action, and the relevant. I'm not talking about the terrorist, but the company, the travel agent, which has already arranged the travel. If no action is further taken, then he will be guilty of doing this with knowledge.
Maybe it took me a long time. I haven't come to that. I'm coming to that. Then will notify the company. It is likely that action will be taken by the company to cancel the flight or part of the itinerary to facilitate law enforcement, even for money laundering and so on. They would do that. Do the airline carriers and the travel agents know about this? There is maximum penalty of 7 years. They are aware of that. Sorry, I'm talking about the scenario, what you said. They have the obligation to cancel or take some action to stop the part of the itinerary. What they are facilitating the law enforcement agencies, if they choose not to cooperate, it doesn't mean that they have criminal liability. Now, this is about the implementation. Now that you mentioned this, before we have implementation, we can have some more communications to see whether there can be some protocol or some guidelines that they can be put in place for the sector. Or earlier than that, that can be done. But as far as we are concerned, this is about law enforcement. Mr. J, if you can anticipate this problem, that this is not unrealistic scenario, can you tell us in the form of a paper how you're going to deal with this? If they do not do anything, would they be caught by the law? Okay. Mr. Felix Chung, second round, please. The DS mentioned surveillance, and the police are trying their best in this regard in overseas jurisdictions. They identify the terrorists normally after an attack, and they would say that they've omitted that person. This person has been under surveillance for a while, but the surveillance stopped and the problem occurred. Now, these certainly would involve a vast network and a lot of intelligence, a lot of resources, and there is no question of doing enough. So should the police be given more resources to have a better network or better intelligence? But if we talk about giving more resources for the police to do surveillance, it would have the negative aspect of freedoms being affected in the overseas jurisdictions, that they may be putting someone under surveillance, but they just omitted this person as a terrorist. Yes, indeed, I agree that surveillance and intelligence would mean so much to anti-terrorism in the world. They are stepping up surveillance in terms of anti-terrorism, and they are stepping up the intelligence gathering in the US, in the UK and France. After the terrorist attacks, they have stepped up the surveillance manpower, and they have improved or strengthened the intelligence gathering and exchanges. I don't go into many detail about their measures, but basically they amended their legislation urgently to tie in with that. As I said at the very beginning, terrorism or anti-terrorism legislation is really fast moving. The fact that you're not doing this today doesn't mean that you don't do it tomorrow. We have to look at the situation. The police are the key force against terrorism. We have the police, customs and excise, immigration, and the ICAC. They have their own respective intelligence gathering network. And what they do is to make sure that the intelligence can be shared between these organizations in terms of anti-terrorism. And we have to review the resources, the manpower resources in particular. in order to achieve the desired effect, shouldn't we have more manpower, or shouldn't we have specialization? If an officer has to deal with a wide variety of different criminals, they may not be able to focus their attention on terrorists. In the UK, in France, or indeed in Germany, they've been putting certain people on surveillance, but for some reason they've stopped, and then problems started to occur. So we are looking at what's happening out there and why they're happening, and review our anti-terrorism regime. We do not rule out the possibility or the scenario of looking at our resources in the light of these amendment ordinance. Mr. Felix Chung. Now, this is to prohibit any Hong Kong permanent resident. The DS said also that there are some foreigners who are working in Hong Kong. When they're coming back to Hong Kong, if they are put under the surveillance list, it's likely that they will be denied entry to Hong Kong. Now, the law is, why don't you mention the non-permanent resident area in the bill? DS. The purpose of this amendment bill is to enforce UNSCR 2178. This idea of the resolution is for the different jurisdictions to regulate their own nationals. In Hong Kong, if you apply this national concept, we have the Hong Kong permanent resident. We are proposing this prohibition. Mr. Chung has got a point that this may not be confined to Hong Kong permanent resident. We have to strike a balance in the bill. Like Mr. Paul Jay said, we have to strike a balance between the legislation provisions and the implications. Now, we're not taking the UN resolution instructions wholesale. We look at Europe, the US, Canada. They have implemented the 2178. Some are more stringent, some are less so. In the mainland of China, they also have the Anti-Terrorism Act, which is couched in broad terms. So each jurisdiction would have regard to their own circumstances. Then we put our emphasis on permanent residents. For other people, the first line of defense would be to stop these people passing through Hong Kong or entering Hong Kong under the immigration ordinance. When the visitors are coming to Hong Kong, they can be stopped if they don't fulfill the entry conditions. Like if they are endangering safety in Hong Kong or security in Hong Kong, they can be denied entry. Now, what if these people are making their way out of Hong Kong? If they are terrorists, and if they are engaging in any terrorist acts, I am confident that they would have been arrested by the police in the first place, and they can be prosecuted under the crimes ordinance. If these people elude the dragnet and they manage to get out of Hong Kong, and if we get sufficient evidence, then through the Interpol and through the cooperation mechanism in the world, we can notify the place of domicile, and the law enforcement agencies will be waiting for them at the other end of the border. Now, these people may be going to certain countries to engage in terrorist acts. I'm sure that these countries must have certain intelligence, and these other jurisdictions may have more intelligence than Hong Kong, and they can find it easier to prosecute these people. The law has to be clear and easily understood. We have to strike a balance between these provisions and the freedom of travel. we don't really want to go to the fullest extent. We have to make it reasonable, and that explains why we confine these to Hong Kong permanent residents. If I may, Mr. Chairman, for exit out of Hong Kong, Hong Kong permanent resident will be committing an offence if they are caught by the law here. Anybody who is financing this kind of travel would also be against the law. It is travel between countries. Let's say the Indonesian domestic helper. She's traveling back to Indonesia and then to Syria. Anybody, not necessarily permanent resident, anybody who is passing money to her, then it would be against the law, because the Indonesian helper has a specific purpose in the journey, and organizing and facilitating is also an offense. But we have to have the mens rea. There is an intention to do so. Now we're here till 10:30. There are still other members who would like to speak. We can extend the meeting till 10:45. Mr. Holden Chow, thanks very much. If I may put a question, I'm not sure whether this has been put before. I was attending the Economic Development Panel. Now, with regard to this bill, if it is for a particular purpose, like terrorism activities, then it will be caught by the law. If someone is intending to leave Hong Kong and we have the evidence that he has the intention to do such and such a thing, then he will be caught. What if someone is organizing or facilitating terrorist activities elsewhere, not in Hong Kong? He may not have a flight ticket in hand, but somehow through the police they manage to identify that someone is conspiring to engage in terrorist activities elsewhere in the world. He may not be traveling there on his own. Now, for financing, I heard you say that this will be caught, but in the scenario that I depicted, there is sufficient evidence that he is organizing and conspiring some terrorist activities in other parts of the world, and he is not flying there himself. Now, in this kind of scenario, is there anything that this amendment bill can do to tackle the situation? Yes. Thank you. Like I said, if someone knowingly and if someone knows that someone else is traveling elsewhere to other jurisdictions to engage in terrorist acts, and if he is financing him, then it is against the law. Now, if this is a permanent Hong Kong permanent resident, now you know that fund can be transferred online. Now, if there is a permanent resident who is financing this in Canada, then under the extraterritorial law, then it's against the law. And also, if you are drawing money from an ATM, it's also against the law. If someone in Hong Kong is organizing and facilitating these terrorist activities or to undergo terrorist training, then it is also against the law. Now, these are the two offenses that we'd like to propose here.
We also have criminal laws in Hong Kong to handle conspiracy. Let's say terrorist training or training in terrorist act or training related to terrorist act. We're talking about acts that may cause serious violence against a person, causing serious damage to property, endangering a person's life. If someone offer assistance or conspires to provide a training, depending on the kind of training provided, it may be an offense against the person, it may be other offenses, for example, the property damage in other criminal laws. In gist, the criminal code, the criminal law system will be able to enable us to catch them. Mr. Chow, any further question? No? Mr. Chair, there's still some time. Perhaps I'll follow up the matter next time. 11K, 11L, 11M are all matters of our concern. 11K tackles Hong Kong permanent residents. The others targets any person. For 11K, no permanent residents is allowed to leave. For 11K, wherever the Hong Kong permanent resident is, we can that person is caught by 11K. Are there international conventions which require us to do this? Under 11K, the prohibition is in respect of is imposed on Hong Kong permanent resident, because this is about the implementation of UNSCR, and they want member states to impose this on nationals. So in the case of Hong Kong, we believe Hong Kong permanent resident would be the right equivalent. For other people in Hong Kong, with other mechanisms to prevent them from committing offenses or from entering Hong Kong. If a person commits any offense, he may be already barred from leaving Hong Kong, or he may already be arrested. If we only know about that person's identity after he has left Hong Kong, we can inform the relevant state of residence or relevant state of nationality to follow up. We are not providing for the prohibition of local terrorists from leaving Hong Kong, because we have to comply with the definition of Section 2, Terrorist Act. If that's already the case, the police will already have arrested that person. So we don't need to prohibit the alleged terrorists from leaving Hong Kong. If that person is a terrorist, it's not possible for us to allow that person to leave Hong Kong. So there are existing laws to handle such issues. We don't need 11K. If the existing laws are so powerful, whether it's a Hong Kong permanent resident or not, and if he's a terrorist, you have already arrested him. In Hong Kong, we don't have this notion that as a resident you be covered by certain prohibitions. For example, in other countries they have laws against child molesters. Whether you do it in Thailand or other countries, you are caught. But for international conventions, you know, when they like the convention, they can make it rather sacrosanct. If they don't, such as the case of a Kyoto Protocol, they just ignore it. The U.S. would like the rest of the world to follow its example. I'm not anti-U.S. I'm just against any hegemony, and Hong Kong is a free place. Next time, I hope we can have a more comprehensive discussion so as to put our mind at ease. Let me say something in response, Chairman. I agree with Mr. Paul Chair, but I need to explain. The fact is, when we table a bill, well, the law is supposed to be an articulation of a policy, and we are partners of this council. We need the public to know what measures we have taken to curb terrorism. For the first offense, we first of all prohibit the person from leaving Hong Kong, and then we also prohibit offering or organizing or facilitating the travel of that individual. That would mean that the system is comprehensive. Please refer to CB 21945 1617 (01). This is a letter from our legal advisor to the government raising certain questions, and we have got a reply in 02. So maybe I can ask the legal advisor to bring to our attention what the matter should be attended to by members. Thank you. The purpose of the letter from the Legal Service Division is to look at the different consequences, legal effects of introducing the amendments. So this would provide a framework for members to consider the bill. And there are other issues in the latter part of the letter, which is about the basic law and issues previously raised by other Bills Committee. We're talking about Article 24 and 25 under the basic law, and why some residents are targeted or are covered by the amendments. The government has offered some explanation. I understand they would supplement the reply with something in writing. And then when that is received, the members can further consider the response given. Some members are also concerned about, Article 31. The freedom to travel. And the last part, we raised this question. This is about the question of proportionality test. So, and we asked why the government is satisfied that the amendments would comply with the article in the Basic Law and the Hong Kong Bills of Rights Ordinance. In the government's reply, page 6 and 7, they have given us a general response. Maybe next time we'll ask the government to say more about the factors that they have considered in considering proportionality, and why they think they think that the proposals in the bill would be in compliance with the basic law and the BOR. All right, thank you, legal advisor. People, please note the information. When we proceed to the cross by cross, we would then have a substantive discussion. If there's nothing under AOB, then the meeting's adjourned. Thank you.